Are you ready on Mr. Schuster's case, Ms. McDonald?
Well, Mr. Schuster, just to give Your Honor a little bit of background on this one, Mr. Schuster is representing himself. The court has previously gone through the waiver of right to counsel. When we were here, I believe the last hearing, Mr. Schuster gave an indication that he wanted to resolve these matters. So I have drafted a plea form with the city's offer on it. I just am not sure how to get it to him. I can certainly send it to him in the chat. I just don't know if he has the ability to download that and sign it if in that respect. So,
hi, ma'am. How are you today?
Hold on a second. So let's preliminary matter. This is Jonathan Schuster, 4A0525748. So it sounds like Ms. McDonald's trying to get you some documents, Mr. Schuster.
Yeah, so for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary. I had mailed out some paperwork over to the prosecution as well as submitted it to the court. Have you received those, ma'am?
So I've received two motions from Mr. Schuster. Have you?
Yeah, the two motions as well as the affidavit, as well as the certified copy of the. So you got that paperwork? Were you able to read it?
I have two motions. One was, both were received today.
Right. You should have received an affidavit as well.
I don't see any affidavits.
It's on the back.
The affidavit was received at the same time that the motions were submitted. And
I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I emailed to Ms. McDonald this morning.
You did? I'm sorry, what, Madam Clerk?
I emailed to you a copy of the first motion to dismiss and the affidavit truth, it's called.
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster. Hold on, Mr.
And
Schuster.
so those were sent over
Hold on, Mr. Schuster.
as well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
Yeah, I just wanted to make sure I said.
We kick things off with classic setup, where the narrator sets the stage for the absolute chaos to follow. You can feel the tension building as the court prepares to deal with a defendant who has already gained a reputation for walking out of hearings and ignoring basic decorum. The prosecutor is already sounding exhausted, trying to hand over a plea deal to someone who likely won't even acknowledge the court's authority to offer it. This intro perfectly captures the calm before the storm of sovereign citizen nonsense.
Madam Clerk, did you send that to my email or did you send it to the office email? Because I don't have anything from you today. Except the orders from Mr. Bailey Garrison and the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine. I just require that due process is, that we.
Okay, hold on, Mr. Schuster. There's going to be plenty of time for you to talk.
Yes. Thank you. Also, the prosecution, I've never received anything from you as well, but there is an email on for contact information, so you can send that over via email if you have anything to send to me.
We sent you discovery at both addresses that you gave to the court, so they were physical copies because there's digital evidence as well.
Well, I just have never received anything from you.
Well, it went out to your mail, so I don't know what to tell you about that.
Did you check, Mr. Schuster?
I mean, I haven't received anything.
That's not my question. My question is, are you checking your mail regularly?
Oh, I definitely look out for mail regularly.
Okay, and does the court have your current address?
So he updated it, Your Honor. We actually had this situation issue a couple of weeks ago, or actually almost a month ago, where we had sent out full discovery to the defendant, and then he indicated that wasn't his address. So we sent out another packet of full discovery to him to the address that he updated. Let's see, the one on Kenyon Street.
2318 California Avenue.
You gave us on January 27, 600 Southwest Kenyon Street, apartment G201 in Seattle.
You're talking about on January 27th when the judge denied subject matter jurisdiction that day?
So the address that you gave to the court on January 27th was the 600 Southwest Kenyon Street, apartment G201. So
The same day that
that was the
judge
Mr. Schuster,
denied subject
did
matter
you-
jurisdiction?
Mr. Schuster, is that the
Mhm.
address you gave on January 27th?
I don't recall, but I do have, somewhere she can send it to so
Well,
that
we're not going to play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it and I don't recall, so I'm giving you an address, but
You recognize that address?
which address?
Can you read that one more time, Ms. McDonald?
Yes, the address on January 27th that he requested discovery go out to was 600 Southwest Kenyon Street, apartment G201 in Seattle. The one prior to that he requested was 1005 North Cleveland Street, apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the judge denied your motion to dismiss for lack of subject matter jurisdiction. The court found that there was
She
subject
did.
matter.
It was on the record. She denied subject matter jurisdiction. She didn't deny my motion. That wasn't until
The defendant immediately jumps into deep end by claiming a special visitation as a beneficiary, which is essentially code for trying to avoid the legal reality of being a defendant. The friction begins instantly over paperwork that magically hasn't arrived. Watching the court staff scramble to check emails while the defendant insists he sent everything is the first sign that this hearing is going off the rails. It is a tactical mess designed to stall for time, but the judge is already showing signs of seeing through the game.
you did receive the two motions as well as the affidavit today. Is that correct, ma'am?
I did. Did Ms. McDonald, have you gotten that yet?
I just
Perfect. Have
So-
you
so Mr.
have you had a chance to read over that, Miss?
So obviously Ms. McDonald has not had a chance to read over it.
Oh, I was referring to
Provided
you,
her.
ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
Well, from the very beginning of this
Remember
matter,
signing this piece of paper saying you were representing yourself?
from the beginning.
That's not my question, Mr. Schuster.
I'm answering your question. I would like to
I don't want a
speak.
narrative, yes or no.
Thank
Do you
you.
remember signing this piece of paper?
I don't recall.
Okay.
I
well,
don't know what paper you're
signature is
showing me.
You're on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just
Schuster-
very hard to read because it's blurry
Okay.
from this
So
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
This isn't the trial.
Nonetheless, I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I've reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion, finding that this court, again, does have subject matter jurisdiction in this case will proceed.
This segment features a necessary reality check as the judge has to remind the defendant that adulting requires letting one person speak at a time. The commentary highlights the sheer arrogance of someone with a room temperature IQ trying to outsmart a room full of legal professionals. The debate over discovery and physical copies of evidence shows the defendant's strategy of claiming ignorance to frustrate the process. It is a painful display of someone who thinks that being difficult is the same thing as having a valid legal defense.
I am also not really interested in hearing that you have yet a third new address for Ms. McDonald to send discovery to. So at this point,
It was never a third. In the beginning, you had the correct address. It's no longer the correct address.
then it's
And
not the
so-
correct address. If it's no longer correct, then it's not correct. You've given a
Well, as of
address.
recent, as of literally not that long ago.
So when did the Kenyon Street address become a bad address?
I want to say within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
It's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated.
I can
And
tell
this
the
is a
court.
court of record, correct?
Is a court of record.
You said this is a court of record?
It certainly is a court of record.
Ah, I see.
We are on the record now. So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that, everybody has the correct information.
What is your current correct address?
The mailing address would be 2318 California Avenue. I believe that's Southwest. D?
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
Family. And so, just so I'm clear, um, you're saying that the right to travel and privacy is not a federal matter, and that
I'm
you're
saying
saying
that
that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington. And that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty, and a right because no person shall be deprived of life, liberty, or property. You're saying that isn't a federal.
Now we get into the address shell game, a favorite tactic for those trying to evade the law. The prosecutor reveals a trail of different addresses, while the defendant plays dumb about where he actually receives his mail. He even tries to claim the case was already dismissed for lack of jurisdiction, which is a bold-faced lie told directly to a judge who has the records right in front of her. It's a desperate attempt to create a jurisdictional loop that doesn't exist, and watching him get caught in his own web is pure courtroom drama.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now,
Right?
and
So
so my
go
email.
you
I'm
can
using
go
the
off
same.
camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on.
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get back on it.
Okay. One moment.
Can you mute yourself, Mr. Schuster, and turn your camera off to read your email?
Oh, I saw that Carmen had sent something over.
Yes, you need to open it and reboot it.
Oh, it says what you had said on the record, correct?
No, it's an entire form. It's about, see how many pages that is? About 8 pages.
Can you mute yourself and take yourself off video while you review that, Mr. Schuster?
I think so. Let me see if I can do this correctly. Oh, so I see everything that you've sent over. Um, Obviously, I'd probably have to look at it longer to make sure I
I'm
read
asking
it
you to
carefully.
I'm asking you to do that now. We're going to go back on the record.
Oh, okay. It just might take some time. I've gotten through some of it, but for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time for all of that, but if you do, I don't mind. Taking the time to fully get into it.
Ms. McDonald, you're on mute.
If he's asking for more time to go over the city's offer and to consider that, I don't have an objection to continuing the matter if he agrees to waive speedy trial.
Oh no.
Well,
if you don't wish to waive speedy trial, then
Well, if she doesn't want to give me more time, then I guess we just got to.
Well, the problem is, Mr. Schuster, you have to be brought to trial within 90 days of your arraignment date. And so your trial is scheduled for next week, but if you want to take advantage of the city's
On the
offer,
11th,
right, if you want to take advantage of
9 a.m.
if you want to take advantage of the city's offer and you want more time to review it, unfortunately, you would need to set over that trial date.
Well, I can counter to you right now if you'd like.
I'm happy to go in a breakout room.
I don't know what that means.
I don't know that these are necessarily conversations to have on the record, but
If you want to go into a breakout room, in other words, go into a separate Zoom room with just Ms. McDonald so you can discuss her offer, I'm happy to allow you to do that right now.
Okay, how does that work? How do we do that on Zoom?
I can do that. I can put you in a breakout room. You'll get an invitation.
Do I
Something
need it? Okay.
pop up on your screen for you to accept.
Okay, so just wait until something pops up.
Yep, I'm going to put you in there right now. It will be into room 1.
How would I come back though?
There will be a button on the bottom right that says leave breakout room and back to main session.
Okay, so it says join breakout room. Prosecutor McDonald is inviting you to join room 1. So I
Yes.
just click join.
Yes, and I'll be in there.
The judge finally brings down the hammer regarding the waiver of counsel. She reminds the defendant that since he insisted on representing himself, he is held to the same standards as a professional attorney. This is where the sovereign citizen fantasy hits the brick wall of procedural reality. He can't just drop motions on the day of a hearing and expect them to be heard. The judge's refusal to let him slide on the local court rules is a satisfying moment of accountability for someone who thinks they are above the standard process.
Back on the record with Jonathan Schuster for A0525748. Mr. Schuster had an opportunity to speak with Ms. McDonald in the breakout room. And Ms. McDonald, where are we?
Yes, Your Honor, I'm a little bit concerned because it didn't appear that Mr. Schuster was, and I was kind of having a hard time discerning whether or not it was a willingness or an ability to track the conversation.
Oh, objection. I definitely have the ability to have a conversation and track what's going on. I offered her a counter and she didn't want to take it. And so that's where we are, ma'am.
So I do have some concerns there. Also, Your Honor, I did just pull up his criminal history. It appears that he does have an active warrant out for his arrest for a DUI.
Active warrant.
SMC bench warrant from 2/14/25.
Yes, that is the one. So I have a couple of concerns. The concern is the defendant is saying he doesn't have discovery. He has not read the reports. I asked him several times if he was prepared to proceed to trial on all 3 charges next week.
And I told her 9 o'clock on the 11th, I will be there.
So,
Mr. Schuster, that you're intending to go to trial without.
Right. And you're saying there's an open warrant? Is that King County? Is that who that's with?
So, Mr. Schuster, the Seattle Municipal Court issued a bench warrant for $5,000 on February 14th, 2025.
Okay. And so I'll need to obviously reach out to them so that we can get that quashed and taken care of.
That is true. You will need to do that.
Which I will do as soon as we're done here.
My expectation, if we're having another hearing next week, is that you will have done that before the next hearing.
Oh, 100%. No need to be walking around with warrants. That is unacceptable.
So, Ms. McDonald, are you raising 1077?
well, I would ask that the court engage in a colloquy because I like I said, I was having a difficult time assessing that because I don't know if it's an inability to track
Objection. Objection.
appropriately or if it's unwillingness.
So Ms. McDonald is asking that I ask you some questions to make sure you're able to proceed.
Objection, Your Honor.
Mr. Schuster, there's
I've
nothing
told-
to object
It's been
to.
on the record. I'm ready for whatever we need to do on the 11th outside of quashing this warrant that I just recently found out, as you've said it. I didn't even know that was a thing. So now I have to just take care of that. The 11th, I will be there at 9 a.m.
This is the intellectual climax where the judge systematically deconstructs the defendant's entire worldview. She explains with surgical precision why a municipal court has the authority to hear driving offenses and why his federal arguments are completely irrelevant. The defendant is left standing there while his constitutional motions are denied before the prosecutor even needs to speak. It is a total wipeout that highlights the legal abyss these individuals wander into when they listen to internet gurus instead of real lawyers.
Her counteroffer, which was very reasonable, she declined. And so the next step would be, for this court would be the 11th at 9 a.m. Is that correct? Is that the right time?
That's correct. Ms. McDonald, do you have the ability to send over the electronic discovery to the courthouse for Mr. Schuster to pick up?
So we would have to, so the electronic discovery, we have the body worn camera and all of that information that had to be burned onto CDs and sent to him because it's too large to send
You said
via
CDs?
email. So that was all sent out to his address. We would have to
You
redo
said
all
with
of
CDs, you said?
Yes.
Some of the body worn cameras on CDs because it's too large to send any other way, Mr. Schuster.
You still use CDs? Is that what that is wild.
Well, you are held to the same standard as attorneys, and attorneys are expected to.
I'm just surprised that you still use CDs.
Is there anyone that your office could, ABC Legal or something like that, that your office could get that over here quicker than the US mail?
Well, we would certainly be able to bring it to our office. Isn't that far from the courthouse, so it's not a difficulty in the transportation. It's just it would take my office probably the better part of the afternoon or tomorrow morning to get all of those burned to another set of CDs because there's several.
So if I ordered that, your office bring a set of discovery here, for Mr. Schuster to pick up, after 10 a.m. on Friday, would that be doable?
I would think so.
Okay, so Mr. Schuster, I'm going to have Ms. McDonald's office make you another copy of the discovery, burn the electronic medium onto CDs, and it's going to be available for you here at the court window after 10 a.m. on Friday. That is going to be the only additional discovery that you get. You need to find a way without driving to get here or get someone here to pick that up for you. That will be the only additional copy of the discovery for you. Will be here at the courthouse for you to retrieve. The courthouse is closed on Saturdays and Sundays. So if you want to prepare for your trial, I recommend that you come Friday after 10 a.m. to do so.
And I'm wondering if we can just pass this for a moment so that Mr. Schuster, I would ask that he read the plea form through in its entirety, because I think that does impart some of the things that he needs to take into consideration, which I don't think that he's necessarily considered, while we take the plea on the Partida Garcia matter.
I'm ready to proceed to trial on the 11th. Outside of quashing the warrant with, you said it was Seattle Municipal or King County?
Seattle Municipal Court.
Seattle Municipal. Outside of quashing that warrant, I am ready. I do have one question though. This is a criminal matter, so who was the injured party exactly?
The defendant tries to pivot to the right to travel, but he is met with a lecture on the 10th Amendment and the state's right to regulate its own roads. The commentary doesn't hold back, calling out the window-licking logic of using phrases like life and liberty to justify driving without a license. The judge remains professional but firm, explaining that multiple layers of jurisdiction exist, and he isn't exempt from any of them. It is a back and forth that exposes the defendant's complete lack of understanding of how the law functions.
City of Lake Forest Park has filed charges.
City of Lake Forest Park. Okay, and they'll be present at the trial. I'll be able to face them.
They are represented by Ms. McDonald's office.
So the city is the plaintiff as well as the judge. Is that what you're saying?
The city is not the judge.
Lake Forest Park is not the magistrate for this matter?
Lake Forest Park is the municipality in which this court takes place. Judge Grant will likely be here next week. She is the judge. She does not represent the city. The city is represented by Ms. McDonald's office.
So the judge doesn't work for the city at all, is what you're saying?
She is a neutral arbiter of matters. She is not representing the city.
So she doesn't work for the city?
No, she works for the courts and the court system.
Ah, okay. And
So,
during trial, the prosecution will be able to bring the injured party forward, correct?
During trial, the prosecutor will be afforded the opportunity to bring forth its witnesses. I suspect that will be.
No, I'm saying the injured party.
I'm talking, Mr. Schuster. Okay.
Oh, I hear you. I hear you. I just wanted to make sure it
The
was clear what I
prosecutor has
said.
the ability to bring forward its witnesses. They have the right to cross-examine any witnesses that you bring forward. You are allowed to bring forward witnesses at no expense to you. You do have to comply with the court rules in terms of giving Ms. McDonald notice of any witnesses that you intend to call. So you can't show up on the day of trial having not notified her of potential witnesses and suddenly
Okay.
this is on her.
Okay, I guess I wasn't clear when I asked you because I wasn't asking about witnesses. I was asking about the injured party.
There doesn't
She's
have
been,
to be a named injured party. The
well,
allegation,
I have the right to face
you have the right
to
to
face the injured party who's making
cross-examine.
these allegations against me.
You have
And
the right to present a
she'll
case
be
on your,
able
Mr.
to,
Schuster, stop. You have the right to present
okay.
a case on your own behalf. You have the right to hear and call witnesses at no expense to you. You have the right to question the city's witnesses. Okay, you have the right to cross-examine their witnesses, but
I also have the
there
right
does
to
not
face
have to be
somebody
a
who's
per se
alleging.
injured party, which is what you're getting
Well,
at.
I mean, in a criminal matter, there definitely needs to be an injured party.
In the final act, the judge demands to know if we're in a trial or taking a plea. Even as the ship is sinking, the defendant continues to mutter about void judgments and unenforceable rulings. He can't even figure out how to use the Zoom chat to receive the plea offer, which is the perfect metaphor for his entire legal defense. Technically illiterate and fundamentally lost. If you enjoyed watching this legal train wreck, please like the video and subscribe to the channel for more updates. And we will see you in the next video.
Jury trial next week. Again, Mr. Schuster, discovery will be available to you at the counter at the courthouse after 10 a.m. on Friday. It is the court's expectation that if you want to review that prior to trial, that you come down here and pick it up. There's not going to be a third mailing of discovery to a new address. The court's not going to entertain next week any kind of arguments for continuances based on you not coming down here or having someone come down here and pick that up. Ms.
Okay.
McDonald's not going to keep mailing things to different places.
Would the court setting an intervening pretrial for Monday as well?
We can certainly do that. We can set a pretrial hearing for Monday.
I won't be able to attend on Monday. Tuesday would be the soonest I'd be able to make it to court.
I would ask for Monday, and I would ask that it be in person, Your Honor. So that we can make sure that he's had the opportunity to review the discovery, and we can have those assurances prior to calling in a jury.
I am going to require you to be in court on Monday morning, Mr. Schuster, 9 a.m. in person.
I don't have the ability to make it on Monday, ma'am.
Why is that?
Well, first, I do have other obligations with work. Outside of that, I had set up transportation to make it up there because, as you both know, I don't drive. And so I had set up transportation for Tuesday specifically to make sure I'd be able to attend that. And so I have no problem attending on Tuesday. I just don't have the ability to physically get there on Monday. Plus I have to work. Obviously, work isn't the main thing, but I just physically don't have the ability to make it there on Monday.
Then we'll set this for Tuesday. It is the court's expectation that you're going to come pick up the discovery. We're not going to entertain continuance motions based on not picking up the discovery.
Of course.
Well, Your Honor, and the other reason that I'm asking that we set it for Monday and that he be required to come is we also have the Goodwin matter that we are still anticipating will be set for trial that week as well. And by then we're going to have a lot more information. And I do want to ensure before we walk through the door on Tuesday morning to start trial that Mr. Schuster is prepared.
Ma'am, I am ready outside of the warrant that was brought to my attention today. But during the recess, I actually had a chance to fill out the forms on the Seattle Municipal.
In the body worn camera And
Since prior to the recess, I am 100% ready for Tuesday at 9 a.m.
My concern, Ms. McDonald, is, to his point, if he doesn't have transportation, I'm not going to ask him to drive here.
then at the very least, do one via Zoom. I'd prefer it to be in person, but I do think that we need to have that.
If you need me here on Zoom, I can definitely do Zoom. That's okay with me. I just physically can't be there on Monday.
Okay. Then that's what we'll do. We'll set a pretrial hearing for Monday. You are authorized to appear on Zoom on Monday, but on Tuesday you are ordered to appear in person.
Okay, and so this went from a readiness back to a pretrial, correct? And then Tuesday we go to trial?
Yes. So today was the readiness hearing. We're going to set a pretrial on Monday, and on Tuesday will be trial.
Okay. Okay. And then other than that, did you have anything else for me?
Anything else you need to address today, Ms. McDonald?
No, Your Honor, I was just double checking my officers. I think we're good on availability. So
You said what now? Your offices were good on availability?
my officers, the witnesses that are going to testify.
Oh, gotcha. It was Carlsbad, I think, or something like that. Either way.
They're all listed in the report.
Gotcha.
And again, Mr. Schuster, the conditions of release in the meantime are that you make all of your court appearances, notify the court of any address changes within 24 hours, no criminal law violations, no driving without a license and insurance. I do expect you to address that Seattle Municipal Court warrant. I'm not sure if they'll be able to clear it by next week, but at the very least, there should be a docket entry indicating that you've set up a hearing to do so, and all other previously imposed conditions remain.
Are you familiar with Seattle Municipal at all, ma'am?
Yes, I am.
Because when I went to the website regarding warrants, there was a form for motions to quash warrants.
Mhm.
Do you know anything about that?
I know that some warrants can be quashed administratively and some warrants you have to show up in person.
Well, just in terms of the process and how to make sure it's handled correctly. Because when I was on the site, essentially what I was getting, I just filled out the form and then submitted it. And then it sent me an email telling me that I would need to wait for contact. Does that sound correct to what you know?